Hi everyone. Today I want to discuss the importance of having a will. Why do you need a last will and testament? Why not just not plan in the eventuality of demise, which unfortunately is one of the truths, right? We can't escape death and taxes. So why take the time to draft a will? In New York State, if you die without a will, anything that you own in your name will have to pass through a court process of either probate or administration. So if you have a will, the court process of probate is made somewhat simpler and cheaper because your executor would not have to buy a bond. So when you draft a will, you ensure a smoother process after your passing. Of course, the first and foremost reason to draft a will, aside from making it easier for your beneficiaries, is that you want to leave things the way you want to leave things, not the way New York State necessarily intends for your assets to pass after your passing. So if you die without a will, New York intestacy statute governs. What that means is your assets will be distributed according to how New York State decided in our legal system is the most prudent. So for example, if you're married with children, your spouse gets the first $50,000 outright, the remaining half of your estate, and the remaining half goes to your children in equal shares. Now, not everybody wants that designation. Sometimes you want everything to go to your spouse. Sometimes you want a specific gift to go to one child and not another. Oftentimes people want to disinherit a child or leave things to a sibling while their parents are still alive. So to avoid the statute governing and to make your voice and your wishes heard, you should definitely take the time to draft a will. So drafting a will is one thing, right? A lot of people are going online these days and utilizing LegalZoom or whatever else they have going on that's sort of like an automated process. You know, who wants to take the time to meet with a lawyer? Just let me put whatever I want in writing, have it, be quickly signed, and we're good to go, right? Wrong, because actually, in order to admit a valid will to probate in New York is not so simple. There are a lot of legal strictures that govern proper execution of a will. There should be 2 witnesses, a notarized affidavit of capacity, in order to really avoid the hurdles of the will not being admitted to probate or taking a much longer time than it already does in surrogate's court. So oftentimes you also hear, oh, it's so difficult, it's so painful to go through probate. Many of you have had that experience, and it's true. It does take 6 months to a year, often more, to even probate a will. We're not even talking about administration here, the process of not having a will and going through intestacy, which is, again, more cumbersome, lengthier, and costlier, more costly. So some people will draft a trust because any trust will bypass that court process. Certain assets don't lend themselves to trusts sometimes. For example, certain co-ops, the boards of cooperative apartments will not permit trust ownership in certain instances. It's not so common, but it happens. IRAs, retirement accounts, are not often best placed in trusts, but when you have a beneficiary designation on IRAs, life insurances, even bank accounts, that all bypasses the probate process because that does not go through your will. However you designate your beneficiaries on those beneficiary forms is how those assets will be paid out. Another very important facet to having a will for younger couples is really appointing a guardian for your minor children. In the event that you and the other parent are either predeceased, God forbid, or are unable, right, in the event of your death, to take care of your children, perhaps you want to designate a sibling or a trusted friend to be the guardian, whether it's the financial guardian or guardian of the person, right, to have physical custody, financial management of their affairs. So you get to stipulate, you get to really dictate to the court what is your preference? And the court will give deference to that. Of course, they vet the individual. They check, of course, sex offender registry and make sure that the person is qualified. But you do have a say in that. So for younger couples, appointing a guardian for their minor children is a very important facet of drafting a will. There's so much more to say about this, and there's so many techniques to having a proper will executed, and also techniques to avoid ever having to go through the probate process. We kind of touched upon, having properly designated beneficiary forms, perhaps executing trusts. And really, this is something that you should go to your estate planning attorney and really be thorough, give a list of all your assets, but also think about what is your agenda? What are you trying to achieve? Are you trying to minimize estate taxes, perhaps? Are you trying to just ensure a much smoother and less costly transition for your children to inherit? Is this a second marriage? Should you be perhaps looking at how to secure what's in the best interest of your children if you pass away prematurely? So there are a lot of issues surrounding estate planning, and certainly not things that we necessarily want to discuss, but very important. We cannot avoid death and taxes. Those are the realities. So think about your planning. The law offices of Irina Yadgarova, my office, would be more than pleased to assist you with all of your needs, answer your questions. So please reach out to us, and we look forward to working with you soon.